Well, welcome to our first oral argument. Very exciting for us. Hope it is for you too. We have three cases on the docket. We'll take the first one, 1524-0087, consolidated with 00090, NRA Google LLC. We'll take that argument. At the end of that argument, we'll take a 10 or 15-minute break. Judge Ferris is not sitting in this case, so we're glad to have former Chief Justice Woody Jones sitting with us. We'll take a break, and then Judge Ferris will be joining us for the second and third case. So, if all parties are ready, we'll hear from Relator, Ms. Hargrove.
May it please the court, good morning. The trial courts below clearly abused their discretion when they denied Google a right to depose the plaintiff on any topics whatsoever. This is a clear abuse of discretion for two reasons. First, Rule 199 allows parties a broad right to depose any person or entity, and the state of Texas is undisputedly an entity under this rule. Second, the topics at issue here seek relevant information that go to the heart of the case. Google is trying to depose the plaintiff. It asks the plaintiff about basic issues such as its contentions as plaintiff and the facts underlying those contentions. The trial courts chose to deny Google a right to depose the plaintiff about any of these matters. Instead, they accepted the state at its word when it argued that the depositions were improper because they were unduly burdensome and called for privileged information. But Texas law, established Texas law, requires the parties seeking to avoid discovery to present evidence in support of its objections. The state did not do that.
Is there anything in the deposition topics that's not in the mandatory disclosures that should have been disclosed at the outset? I mean, it looks like it's name and address, legal theories and contentions, calculating damages. Looks like the vast majority of what you want to depose them on is a matter of disclosure. Am I right about that?
I do think a lot of it should have been disclosed in the initial disclosures. Those are not in the record. The state has not presented the evidence that it has provided any of this information to us in written discovery. But it's important to note that depositions are unique. Depositions are a procedural discovery device that are available to all litigants and that allow us to get information that you simply cannot get through written discovery. In particular, and important here, is the ability to ask follow-up and clarifying questions on what is, that is just irreplaceable.
Did you move to compel the disclosures?
To my knowledge, we did not move to compel the disclosures, Your Honor, but I don't believe that would have cured the harm to Google in a case like this because of the paramount importance of depositions. It's also important to note, Your Honor, that depositions are of critical importance to the discovery process, of course, as we all know, but it's also a method of getting trial testimony. We have the right to present the testimony of the plaintiff at trial. And so by being deprived of our ability to secure this basic discovery right, as well as this trial testimony, there is irreparable harm here.
Ms. Hargrove, I know it's just getting down the road, but let's assume for a second we decide that Google was entitled to a deposition. What's the remedy? Does this court have to go topic by topic in both cases to decide whether the state met its burden of proving those objections? Because there's some objections that require proof, and there's some objections like relevance that do not. Do we have to go through each of those, or if we decide there's a right to a deposition, do we remand for that determination?
Your Honor, I believe the court can do either because of the posture that this case is in. The only way that the trial court's orders could have possibly been upheld is if each and every single topic in both deposition notices were improper for some reason. And so I think that gives the court the flexibility here to either choose to say, A deposition is appropriate, and on remand, the parties are directed to meet and confer, as they should have done from the beginning. The trial court can resolve individual issues on the topics, but I think it's also within the court's authority and power to decide that particular topics are proper, kind of on their face. And I think that doing so in this case would likely be helpful and the practical and most efficient way of addressing this dispute. But I would say that because there was no meet and confer process here, I think it would be improper to, for example, strike a topic down altogether as overbroad when we didn't even have an opportunity to work with the state. We were deprived of that opportunity.
I assume that your position would be that if even one topic is proper, that the trial court's order was an abuse of discretion.
That's correct, Your Honor. Because of the way this was just an up-down ruling, that we just don't get a deposition on any topics at all, no matter what.
And so you would concede the state is not a state agency. State agency's got to be an agency of the state, and the state can't be an agent of the state because it is the state, right?
Well, what I would say, Your Honor, is that if you look at the text of Rule 199, when it applies to governmental agencies, the only way to read that is it includes a situation like this one where you have a governmental agency suing on behalf of the state of Texas.
So the problem, so clearly the Attorney General represents the state and all its agencies in court and litigation like this. And so clearly they're the attorney. I would be extremely troubled if people could use Rule 199-2 to depose their opposing attorneys. And I assume you would be too. And so how can we do that here? I understand since they represent the state, they're going to have to be the ones who say what our contentions are, what our calculation of damages is, but hence my question on disclosure. Normally that's handled by disclosure. Normally when you depose an entity, they prop up somebody from the company who, or an investigator, or whatever their expert witness is going to be. And I bet the Attorney General could do all of that. And I will intend to quiz them about when they're planning to do that, because for crying out loud, there's nothing that's more frustrating to trial judges than, you know, here's our mandatory disclosure, and the answer is all, we object, and we'll tell you later, and we'll supplement, and they never do, and then you end up in big fights about what comes in trial. But I'm just, who would you prop up? Because the Attorney General is not the state. It's just the attorney for the state. So who's going to show up? Going to have the governor show up, or the governor's chief of staff, or somebody from the legislature? I mean, the Texas Supreme Court has expressly said that the Attorney General doesn't speak for the legislature. So I'm troubled by, I don't disagree, the state is an entity, but it's not like other entities. So how do we deal with that problem?
I think, Your Honor, it's important to remember what the topics in play here are. Most of them go to what are your contentions and what are the facts. And these are not privileged matters. I agree it would be improper for us to quiz opposing counsel on the details of their legal theories, and that's not what we're trying to do. But the AG acts in a number of different capacities, and I would suggest that one of the capacities here is essentially as plaintiff. And that's all we're asking to do is depose the plaintiff. But also because this is a corporate representative deposition, there are protections available through that procedure. The Attorney General can designate whoever it wants to testify. It can be someone who has never touched this lawsuit.
Or whoever they're going to call at trial. It could be that
Or
person.
whoever they're going to call at trial. Exactly, Your Honor. Yes. And I think we have the right as the defendant to ask someone some questions about this lawsuit. We just do, and to have that testimony at trial as well. So I think the corporate representative procedure itself provides some protections, and I think as well, the Texas Rules of Civil Procedure as a whole provide those protections because they they give you a way of invoking privilege and protecting for privilege as the questions develop in the deposition.
Do you know who at the state receives citizen complaints about alleged violations? Is it the AG's office or somebody else?
Your Honor, it is the Consumer Protection Division of the Attorney General's office, and we would suggest that that is an example of a capacity the Attorney General serves in that is not just legal counsel in this specific lawsuit. And we, in fact, have offered to depose that agency, and they're objecting to that as well. We haven't been allowed any depositions. And so we really are in a position where we're defending a case. We haven't been allowed a single deposition, and the other side has had something like 130 to 150 hours of depositions. And so it's essentially a unilateral discovery situation, and the logical extension of the state's arguments here are that anytime the AG brings suit on behalf of the state of Texas, the other side doesn't get basic discovery. And that's a pretty big slippery slope that we're looking at, if that's true.
On the other hand, I understand there's some isolated trial courts that have ordered yes or no about the state being deposed. But I didn't see, maybe I missed it, either side citing a case where this has ever occurred. So you would be the first if we have to write on it, and we have to explain why. And if this is such a, people have seemed to been able to live without deposing the Attorney General as a corporate representative. For some of the reasons I described, they're your opposing counsel. And the last thing, I mean, I'm also been around for a while in this game. I've never seen anybody allow depositions of the opposing counsel. We just cannot get into that because it's, everybody will do it. The state has to join many times as a party, or at least intervene whenever the Constitution out of a statute. People are claiming statutes are unconstitutional all the time. We can't depose the Attorney General in all of those cases. We will have it, they'll have to have a new division. I'll have open records, consumer protection, and testifying, attorneys. How is this gonna work?
So I would take issue a little bit with the idea that this has never happened before, because I'll say we put examples in the record. For the last 20 years or so, at least my law firm has deposed representatives of the Attorney General over and over again in cases where the state is a party. And there are examples of this in the record.
Based on trial court's orders or based on, was it
Often by
challenged?
agreement of the Attorney General, but we do have at least one example in there of the trial court ordering that to happen.
But there's
The
no,
Meta
but
case
there's
is
no
another.
opinion giving us an analysis to follow.
That is correct within Texas, because frankly, I think until recently, the AG didn't start raising this objection, and so it just really never came up. We have included some federal authority in our briefing, Your Honor, where courts have really wrestled with this issue. There's I believe it's the SEC v. Merkin case that actually looks to Judge Scheinlin, the discovery expert on the federal rules, and then kind of really does a deep dive in the context of an SEC enforcement action about how this should work, and essentially concludes that because this is a corporate representative procedure, there are protections in that. And anytime you're deposing a corporate representative, for example, attorneys are getting them ready. I mean, that happens any time.
I don't doubt that, whenever somebody responds to a deposition on the contentions, they're doing what their attorney told them to say.
Yes, and I think I would suggest that looking at those cases can be helpful because of sort of those fundamental guidelines that can guide us. But the idea that the alternative is that the state can sue anyone it wants in an enforcement action and not have to answer fundamental questions and not have to testify gives an enormous amount of unchecked power to the state, and essentially gives the state a pass on the Texas rules of civil procedure. If you look at the text of Rule 199.1a, it allows the deposition of any person or entity, and that the state is an entity. The AG is trying to focus on very hyper-technical reading of the procedures in 199.2 in a way of avoiding a discovery right that is just in the plain language and structure of the rules.
I feel like I'm missing something, because you're not, I mean, you alternatively asked for the Attorney General's office deposition, but you're asking for the state, who is the plaintiff's deposition. So you're not directly, at least asking for the state's attorney. You're asking for the state's deposition, and they can designate whoever they want.
That's exactly right,
They
Judge.
could designate someone from an agency, they could designate a non-attorney, whoever it is. Am I missing something, or there's so much briefing on what 199.2 means? Isn't 199.1 dispositive of whether a deposition occurs or not?
Absolutely, Judge.
Okay. And then is 199.2, the term organization and entity, why are they different? Why, do those mean the same thing? Are they different?
Let me just say for the clerk, since one of the nice things about being Chief Justice, I'm going to unilaterally give both sides 5 extra minutes since I talk so much. And took up so much of your time. So I'm going to give my colleagues a chance to ask a few questions and you to spend some of the time of what you plan to say before I interrupt.
Thank you, Your Honor. In response to your question, Justice Field, yes, Rule 199.1A is dispositive because it governs who may be deposed. 199.2B governs the procedure for bringing that deposition about. You're right, it does use the term organization rather than entity. Neither the rule nor the comments explain why. My guess is that it makes sense because in that context, you're explaining that the procedure is a little different for an organizational witness as compared to an individual witness, and that may be why that language was employed the way it is. But if you look to dictionary definitions, for example, of the terms entity and organization, they match. They're very much coextensive, and I think the use of the terminology other organization at the end of the list of possible organizations in 199.2B shows an intent to expand the scope of that provision to match 199.1A. And also, if you look at the rules regarding essentially enforcing the right to a deposition in 215.1, that rule goes back to the entity language. It says, if a party or other deponent, which is a corporation or other entity, fails to make a designation under Rules 199.2B1, the discovering party may move for an order compelling a deposition. So I think when you wrap all of these rules together in context, you see that the intent was to allow you to take the deposition of any entity, and certainly to interpret the rules in such a way that you cannot depose a party, so it simply can't be what the drafters of the rules of civil procedure intended.
199.2 uses the phrase other organization, but it is patterned after Federal Rule 30B6, I believe. 30B6 says other entity. Do you know or have any idea why the state uses other organization, whereas the federal rule says other entity?
I do not know the answer to that, but I think, again, within the Texas rule, you look at the rule that describes who may be deposed for your answer to the question of who may be deposed, and it's as simple as that. And I think that, in particular, if you look at the use of the word in 199.1A, the fact that they use the word any to describe person or entity that is subject to deposition, that's extremely important. That's a broadening term. Any has been interpreted by the Texas Supreme Court to mean every. And so I think if you look to 199.1A, you see that the idea is sort of no matter what form you may take, you're subject to deposition, especially if you're a party. And also, Your Honor, we do have a number of federal cases cited in our briefing from interpreting 30B6. I haven't seen the answer to your specific question in those cases, but they do apply 30B6 to allow the deposition of the United States. The last point I'd like to make before I sit down, and I thank you for the extra time, is just a reference to the NRA USAA case out of the Texas Supreme Court a couple of years ago. I think that case is very on point here. It addresses a situation like this one where you have a party to a lawsuit who's claiming that they don't themselves have a whole lot of personal knowledge, claiming that therefore it would be very burdensome to have to present a witness for deposition. And the Texas Supreme Court went through all of those arguments and rejected them in the context of a corporate representative deposition and said, you need to educate yourself. You know, the parties generally have the right to depose each other. It would be, quote, highly unusual not to allow the deposition of the party, the other party in a lawsuit. And so I would recommend that case to the court as a little bit of a roadmap here.
In that case, the Supreme Court specifically rejected the idea that you have to do written discovery first.
That's correct, yes. The court confirmed that parties have the right to elect what type of discovery procedure that they want to use.
But this is an unusual case because in most corporations or other entities, you don't have a separation of powers. I mean, the Attorney General cannot bind the legislature or the governor or vice versa. And so we have a bit of an organizational problem. Who represents the state when the state is actually three separate branches of government? That's what troubles me. Is there any other analogous situation you can think of? You can think about it for a while, but I'm just...
Yes, it is unusual. I mean, I would suggest that what the statute says is that the state of Texas appears by and through the Attorney General. And so I think in that sense, the Attorney General is not just acting as outside counsel. It's acting as the party in that sense. It's representing the state. That's what the legislature said should happen. The state has made decisions about what claims to bring. The state will make decisions about what motions to file, about what positions to take at trial, what testimony to put on at trial. We're allowed to ask about all of those things.
Thank you, Ms. Hargrove.
Thank you.
We're ready to hear from respondent or appellee? I don't remember.
No party interest.
Okay, thank you. Mr. Cole?
Thank you, Chief Justice Brister, and may it please the court. The two mandamus petitions before you this morning present, as I see it, two overarching issues. The first is whether the state, qua state, is required under the rules of civil procedure to sit for a corporate representative deposition. The second is whether the Office of the Attorney General, as you said, opposing counsel in this case, is required to sit for such a deposition. Now, we would submit to your honors that the answer on both scores is no, and that neither trial court on these separate records abused its discretion in so holding. And I want to highlight a point that Chief Justice Brister made at some point during the argument last time. And I think the best case for Google here in this posture is the following. They cite some cases on one side that said maybe you can get a deposition of the opposing party's lawyer. They cite a District of Nebraska, cite a District of Ohio, District of Utah. We have some cases on our side going one way. Well, if that's the case, if there's cases on one side, cases on the other side, definitionally that can't be an abuse of discretion warranting the writ of mandamus in both cases. And so I think the easy way here is to look at that. I mean, that's not an abuse of discretion. But before we dive into the OAG issue, I do want to start for a moment with the state as such. And so our position, of course, is that the state as a sovereign entity is not required to sit for a corporate representative deposition. And I think the interplay between 199.1 and 199.2 are relevant here. So 199.1 really talks about the how of a deposition. If you look at the statute, it's talking about the methods for a deposition. It says
199.1?
199.1, yes.
I thought 199.1 talked about who.
No, that's 199.2. So if you look at 199.1, it says oral examination, alternative methods of conducting or recording. It's talking about subsection A says generally. It's stating a general rule a party may take the testimony of any person or entity by deposition on oral examination before any officer. B talks about depositions by telephone or other electronic means. C talks about non-stenographic recording. It's talking about the how. How do you do this deposition? Now,
You just read the provision that says you can take the deposition of any person or entity. I mean, isn't that the key language for us in this decision?
I don't think so, Your Honor. I think it's 199.2, and here's why. So I think it's talking about, A is talking about the typical way, the general way you take a deposition here is oral examination. Now, if you go to 199.2, it's talking about the identity of witnesses subject to a deposition, and it lists the witnesses. And among those, you find an individual or public or private corporation, partnership, or other organization, and you find the governmental agency. So,
So you're saying 199.1 says any person or entity, and 199.2 then just says we didn't really mean any person or entity, we just mean the ones we're listing now.
no, I'm saying 199.1 sets forth a general rule that is later subject to exceptions. Of course, it doesn't mean literally any person. If I want to depose somebody about everything that's all privileged, obviously it doesn't count. You don't get to any deposition, but it's talking about, it's talking about the witness.
I don't have it in front of me right now, but doesn't 199.2 use, isn't a list a non-exclusive list?
I think the list doesn't include the state. Let me go to that list if I might. The list.
No, but first, is it exclusive or non-exclusive?
Other organization captures other types of entities not listed. They list a couple of things that might well be the case, LLCs, nonprofits,
Does
of
it
course.
use the language only these entities, or does it use the language including these types of organizations?
No, it says including, but here's why that list doesn't include the state, if I might, Your Honor. So you see that it says individual, public or private corporation, partnership, association, governmental agency, or other organization, as a threshold matter. The state is not listed there. The governmental agencies are listed there. And now here's the category error I think Google's making here. The state is not, like all these other entities here, a unitary closed organization that in the way that Google is, for example. So the state is made up, as Chief Justice Brister has pointed out, of many independent, separate, many of which are constitutionally created offices. And here's where the rubber meets the road. So in the same way that Google can go to its marketing department or its R&D department or its accounting department and compel somebody to come sit for a deposition, we can't, as Chief Justice Brister said, go to the governor's office or the Railroad Commission, or how about in this case where they said they want a deposition about the cookie tracking technology in the General Land Office. The Land Commissioner is a separately elected constitutional officer. We have no means to compel the Land Commissioner's office to send us somebody for a deposition. In the same way, we can't go across the hall to the Chief Justice and say, Google thinks that maybe the judiciary is tracking the biometric information of persons.
We are an other organization.
I'm sorry?
We are an other organization.
The state is not another organization because the common thread between all of these other organizations is that they're a unitary closed entity with a principal or head that can compel actions. Again, the Office of the Attorney General can't compel the judiciary to send a representative here.
I guess my question is, can somebody, if the 15th Court is sued for some reason, we already have been sued for being unconstitutional once, and the question is, can we be noticed just right out of the gate? Send us somebody from a deposition.
If you're a party to the lawsuit?
Yep, somebody
Well,
sues us for discrimination or whatever else.
Well, if you're a party to the lawsuit, that's quite different. But this case is, if their rule then, if that's where we want to take it, their rule then is that anytime the state is a plaintiff, any agency in the state is subject to a deposition. That's not the rule. There's no case that says that, and that's important.
But
Certainly.
isn't that different, what you just said? I mean, we're not saying any state agency can be forced to take a deposition. We're saying you state or the plaintiff, we've noticed your deposition as an entity, and now you as an entity can decide who testifies on those various subjects. I feel like we come to that piece part of the road and then they veer over here to other issues. What's the answer to that?
So I think not, Justice Field, because of this. We can't compel an independent constitutional agency to send somebody to us to go sit for a deposition. They may not even be able to talk to us about certain internal procedures separately when they're not represented. So there's no way to compel these independently created agencies of the state to come sit for a deposition just because the opposing party has noticed the state as such. I mean, the easy way to cut the Gordian knot here is just what Section 199.2 says. It's notice a governmental agency.
My guess is that if the state or the AG's office asked a state agency to designate a representative and the state agency said, no, we're not going to do it, I bet the trial judge could do something about that.
Well, I'm not sure because I don't know any rule that says that every single agency in the state is somehow before the court within its powers to compel them to attend. Now, to be sure, what I was just about to say is the way we resolve this is just what 199.2 says. You serve a third-party subpoena on the governmental agency. But I don't think the state itself, by merely being a plaintiff in the lawsuit, means that it's open season on every agency in the state for discovery. I mean, that's the upshot of what they're telling you is the rule. But unfortunately, there's no case that says that, which again is important in the mandamus context, where they don't have to just show that they're right as a de novo matter, which of course we would dispute, but it's an abuse of discretion. And they know
keep
that.
Coming back to, they're talking about policy. And as a court, can we even decide policy as an intermediate appellate court? We're not the Supreme Court.
Sure.
As an intermediate appellate court, can we decide that any entity doesn't mean the state of Texas when page 10 of your brief says the state of Texas is an entity and the trial court pleadings that the state filed says we are a sovereign entity? Does any entity mean any entity, or does it mean something else? And if the answer is because of policy we can't get there, that's not a good answer for the court. So how do we get there?
No, it's not a pure policy matter. It's a matter of text. And again, I think perhaps you and I just have a disagreement on the import of Rule 199.2, which I think is critical. Again, I'll go back. 199.1 says it's stating a general principle about the methods of a deposition, oral examination. It says any party or entity, but that general rule is later qualified in 199.2, which lists the, quote, identity of witnesses that may be noticed. And again, the state does not appear there. And so I think it's actually 199.2 that controls here.
Let me ask you about the interaction between those two rules.
Yes, sir.
We've been instructed by the Supreme Court that the rules of civil procedure are to be liberally construed to allow the fullest discovery. Doesn't that mean that if there's any ambiguity, we have to construe the rules in favor of allowing more discovery rather than less discovery?
I certainly don't think that's what it means in the context of a mandamus petition where you're viewing the trial courts.
In general, forget about mandamus.
Well,
Is that what it means? That when we are construing the rules of civil procedure, if there is an ambiguity between two rules, we have to construe it liberally, which means if there's an ambiguity, we have to construe it to allow more discovery rather than less discovery.
I suppose if you get through all of the sort of textual analysis and structural analysis and all of these things, and all you're left with is this sort of presumption, then it's possible, but I don't think you're there. And I certainly don't think you're there, and I know you wanted to say just separate it out from the mandamus petition, but I really think that's a key thing here, because this is asking whether the trial courts abused their discretion. And so if you were convinced as a de novo matter that they're right, it's just not, that's not where, that doesn't entitle them to mandamus relief. It has to be a clear abuse of discretion, which is extraordinary, an extraordinary writ. And so I don't think you have to get to sort of, we've exhausted the text and the structure, and now we need to go to sort of this general background principle of the law. The text, I think, resolves this, again, with 199.2. They're listing the agencies. And again, the way to solve this, I think, is quite simple, is they serve a third-party subpoena on the governmental agency with which they want to ask information from. And they know this because they've been serving subpoenas on school districts and things of the like. And so that is, I think, the simple way to resolve this impasse here. That's what they need to do. But simply listing the state in a notice of deposition, there's no authority that I'm aware of that indicates that that's appropriate, because the state is just different in kind. It's not a corporation. It's not a closed unitary organization in the way that the other types of entities listed in 199.2A are. And so I think that's a significant difference.
So do you don't disagree that most, if not almost all of the topics they want, they're entitled to?
I'm sorry, most of all the...
all the topics they want to depose the state on, they're entitled to know what your contentions are. They're entitled to know how you're calculating damages. They're entitled to know how many people have complained about biometric data.
Well, let me go to a couple of those examples.
No, that's a yes or no. They're entitled to that. I mean, I can,
They-
you're going to have to concede that.
Oh,
Because if you don't, you're going to show up at trial, and when you try to put on damages, what's the trial judge going to say? You
Right.
didn't disclose it, you don't get any.
Yes, I'm happy to concede that they're entitled to those things because they have gotten those things, and they're just not entitled to them in this case through a deposition. And so let me explain why. Let's take, for example, the penalties issue. You'll note that the penalties issue has been subject to expert testimony. They've gotten expert depositions already on that in the Victoria case. They will in the Midland case. So there's expert testimony on that. Complaints we think are not relevant to the case, but let me set that aside for one moment. We've produced the complaints to them. They have those things, but they're separately not relevant to the case. And I think if I might, I'll fit this within my second bucket, which is that why they're not entitled to a deposition of the OAG itself. The topics are kind of overlapping in both cases, but they are entitled to some of those things, just not in this case through a deposition. So let me start in the Victoria case, if I might. First, at the threshold, the deposition of the OAG was noticed after the close of discovery. I mean, that by itself should be enough, I would think, to show that they're not entitled to this in a mandamus posture. But let me set that aside and move to the next point, and it's that, as you were saying, Chief Justice Brister, the OAG is the opposing counsel in this case. There is no real tradition or practice of having the opposing counsel sit for depositions about their contentions of the case. So you talk about contentions of the case. I mean, if you look at their topics, they're asking for legal interpretations. They want to know what we think the statute means. And with respect, that's a proper subject of law and motion practice, not a fact deposition. And that's one of the key problems here. They're trying to sit a lawyer in the chair from the Office of the Attorney General and say, what do you think this statute means? What do you think, how do those facts apply to this law? And that's simply not appropriate to oppose the opposing party's lawyer about it, precisely because all of that is work product. It's privilege.
Let's talk about penalties.
Yes, Your Honor.
I feel fairly confident that the number and nature of consumer complaints, for example, would be relevant to the issue of harm to the citizens of the state. And harm then would be one of the factors to be considered in determining a penalty.
So I would respectfully disagree on that. Harm is not a relevant consideration. Harm to a particular consumer is not a relevant consideration under any of these statutes. It's not in the text. And if you look at the DTPA statute, the factors included, harm's not in there. So the state doesn't need to even bring to you a consumer and say a consumer has been injured. Again, this is a civil enforcement action on behalf of the state. So I respectfully would disagree. That's not relevant here in the sense that it's not an element of the cause of action or a remedy that needs to be proved.
Okay, so you're saying that harm to the citizens, harm to the party is not relevant to the amount of penalty. Is that what you're saying?
It's not one of the factors that's listed in calculating penalties, yes. But on the penalties issue, I mean, number one, the penalties issue is going to be something that's subject, again, of expert testimony. There's expert reports that have produced expert discovery that's already taken place, including depositions in the Victoria case. And in the Midland case, there's also going to be expert discovery when it's time for that, including depositions of our expert. The simple point here is that they just don't get to depose the other side's lawyer about that, their contentions about it. Again, that's the province of expert testimony here.
As your opposing counsel said, I think it's the Consumer Protection Division that receives citizen complaints. Is that right?
Yeah, that comes into that.
And so they would not be acting as the state's lawyer in that situation, would they? They would be just receiving complaints.
Well, I'm not really sure what they're talking about. If we're talking about how we interpret the complaints, that would be a legal interpretation. I mean, the Office of the Attorney General, of course, is made up of lawyers and their support staff who are essentially their agents and so covered by the privilege. But if you're talking about...
It's a simple matter. A citizen calls and says,
Sure.
I have found out that Google is using my biometric data for da-da-da-da-da.
Yeah. I'm not saying that that's privilege, but I'm saying we've produced those things. We've produced citizen complaints to them. They have them. So
Now they're not allowed to take the deposition of the person because they already been produced.
I'm sorry?
They're not allowed to take the deposition because documents have been produced.
No, what I'm saying is that they wanted to depose a lawyer about how they interpreted those complaints. I don't understand the deposition topics to be suggesting they want a file clerk who received the call or something like that.
Isn't the easier argument on, I'm finally gonna throw you a softball here, isn't the easier argument on the OAG deposition just that they're a third party and they haven't subpoenaed them?
Well, sure, they haven't, well, they have issued they've noticed the deposition. That's also another argument. I'm happy to take that, but I think,
I mean, isn't
again.
that right? Aren't they a third, I mean, isn't that the core issue here, that the state's a party, they're an entity, the OAG represents that entity, but they're not a party to the law?
Sure, it would be as if we asked to depose the other side's law firm. Yes, I agree with you about that.
Right, you'd have
They-
to subpoena Scott Douglas to
Sure,
appear.
sure, that's right. But I think one of the other relevant things here to consider is that the state doesn't have any percipient witnesses to their violations. I mean, so they say they want the underlying facts, but the underlying facts are housed in Google. So you asked earlier Chief Justice Brister about what's going to happen at trial, when are they going to get this information? Well, I don't want to speak for the trial lawyers that are going to try this or bind them to anything, but what I suspect is going to happen is that Google's witnesses are going to supply much of the information at trial, and then we're going to have expert testimony. So I don't think it's a surprise here that Google may be having, as I think they're saying, they sort of point to this asymmetry here that we've had to respond to more discovery. But of course, it's Google's conduct that's at issue. State's conduct's not at issue. So it's unsurprising that Google would.
They know if they're using biometric data for commercial purposes without telling anybody.
Quite right, quite right. But it's not OAG, it's not the state, it's not, I mean, one of the deposition topics, just to pull it out here, the Victoria deposition topics, 11 through 14, they want information about the use of cookie tracking technology across 10 separate agencies, from river authorities to the General Land Office. I mean, first of all, their conduct is not relevant, and the only way it's relevant here, and let me spot them this, they want to say it's relevant to a selective prosecution claim. Well, the trouble is, in the Midland case, the state was granted summary judgment on that. So that's no longer at play. In the Victoria case, it was never even raised. So again, that's not relevant. It's just a sort of a fishing expedition.
You can raise that objection with the trial judge and say, the fact that if you're plaintiff suing the defendant for running a red light, you can't ask the defendant, tell us every red light you've run. Because
Sure.
if it's not this one, it doesn't matter.
Quite right, quite right. And that's also relevant because, again.
But you can raise that with the trial judge.
Well, and the trial court, again, granted our.
In toto, but not line by line, and that's one of their objections.
I'm sorry, can you rephrase that?
That's one of their objections. The trial judge just said you can't depose the state, period.
Well, so a couple things about that. First, the orders in this case aren't reasoned in the sense they didn't write out their analysis. So, of course, the court is looking to what's in the record. And you spoke earlier about, well, are we supposed to go through this topic by topic and determine? I don't think that's necessary or appropriate in a mandamus petition context. Again, we're looking at this through an abuse of discretion lens. And so we look to the record to see what's there. And it's in the record. These objections were raised in the motion to quash, the objections, the oppositions to the motion to compel, even on the record before the trial court. So the trial court had this stuff before them. And so.
But do you agree that if there's kind of two pieces of the analysis. If you decide the state has to sit for a deposition, then the second question is, are these topics, did the trial court correctly sustain the objections to every single topic? Isn't that correct? That's our review?
So let me tease that out into sort of two buckets, if I might. So there's the state as such. I mean, we're saying the state is not, under the rules, under sort of matter of common sense, is not subject to a deposition here. If we go to Google, the Office of the Attorney General, then we're looking at it, but I don't think that requires you to go through this with a fine-tooth comb and say, topic 32, topic 16, is it relevant, is it not? I mean, as a general matter, we have some cases on our side, the SEC cases, which I think are quite relevant, Gandy, Contrarian Press, Rosenfeld would say, we look at the topics and say, if this is inevitably and inescapably going to lead to a deposition where privilege is invoked for 6 hours, that deposition just doesn't happen.
Yeah, but my question's a little different. Assume for a second, I know you don't want to, but just assume the state has to sit for a deposition. And then the question is, in Midland, they put 18 topics, in Victoria, they put 32 topics. So we've got, quick math, that's 50 topics. if we decide that the state didn't meet its burden, because you agree, right, that the state had the burden as the party resisting discovery to prove its objections. If
Yes.
we find that they didn't meet their burden on one topic, that would be an abuse of discretion, right?
Well, I want to be careful there because you're looking at the trial court's decision through an abuse of discretion. So maybe in the trial court we had the burden, but here you're looking to what the trial court did. So I don't think it's a de novo question. So
Well, I agree with you.
Okay.
But, so we got two questions. One's an interpretation of a rule.
Yep.
Pure question of law. And if the trial court missed that question of law, that in itself is abuse of discretion. But secondly, then you look at the topics, and if the trial court incorrectly sustained an objection to one of those topics, wouldn't that also be an abuse of discretion?
If you think it was an error as to one of the topics, then maybe you would send it back down on that one topic. Sure, I don't disagree with that.
But the, in the USAA case,
Right.
USAA raises the same objection, saying, we don't know anything about what happened in the car accident.
Mm-hmm.
They know about it.
Yeah.
And so it's superfluous to take a corporate deposition, and Supreme Court says no. But they say USA could have disclosed documents or referenced previously disclosed documents providing the information in its possession regarding liability and damages. That information, combined with lack of personal knowledge, could show that the corporate representative's deposition would provide little, if any, additional benefit. In other words, if you can show with documents, if we send you back and say, you got to go show the trial judge that you have disclosed all your contentions, you have disclosed in detail, and you have disclosed all your calculations of damages, and then ask the trial. That's different from just saying you can't depose the state.
It'd be a different analysis. I agree with you. Yeah. I don't think you need to get there, though. I don't think,
Of course not.
and I don't think you need to go line by line. I don't think that'd be appropriate for a mandamus review, again, where you're looking to clear abuse of discretion. I'm not aware of any case where that is an appropriate role for an appellate court. I mean, maybe you could see that in a sort of de novo context, but here again, it's an abuse of discretion. So you're looking to see what was before the trial court. And again, the orders don't have the reasoning in them.
Before we run out of time, I want to ask
Sure.
a couple of questions about what you just mentioned. What was the record before the trial court? You, the state, as I understand it, filed some evidence in this court after the hearing.
Sure.
What is it that allows us to consider that evidence?
So I don't even really think you need to get into that because that evidence goes essentially to the equity component of the mandamus test. I think you can resolve this on the abuse of discretion prong by saying simply neither trial court abused their discretion. So we're not trying to use that evidence to sort of buttress the abuse of discretion point. It goes to equities and it goes to some sort of background information. I see that I'm out of time.
Did you give him his extra 5 minutes? You are out of time.
If there's no further questions, then we would ask you to affirm. Thank you, Your Honor.
Ms. Harko.
What we are seeking here is a deposition of the plaintiff. We don't want to depose the other side's lawyer. We just want to ask the party suing us some basic questions about their contentions, about the facts in this case.
And of course, those of us who've been around, like my friend Mr. McConico and other people in the courtroom, know what depositions are for. Is you go through this whole thing and you pull out, cherry pick a line here and a line there, take it out of context and try to make the witness look bad. That's why we love depositions. That's what's fun about them. That's, because it's, and then the other side objects nuptial completeness, and around and around and around we go. And considering the other factors here, why did you not move to compel all these things, which your client knows whether they're doing any of this stuff or not? Why did you move to compel all of this? Why didn't you move to compel the disclosures rather than just hauling off and taking the depositions and see what happened?
We have moved to compel on other discovery devices. We argued, in fact, a number of motions to compel on interrogatories, just like last week in Midland. The state has refused to answer contention interrogatories in Midland, taking the position that doing so is improper because it would be providing legal advice. So we've got a very difficult situation on our hands where we're being forced to move to compel on every last thing. And at some point, depositions are ultimately a lot more efficient, and especially the corporate representative.
Again, I'm wondering, so the potted plant rule, so, the attorney representing the attorney with the Attorney General's office cannot say anything except objection. It can't explain why unless you ask them. So how does that work when they're both attorneys? This is not what depositions were set up for, I wouldn't seem like.
There's a federal case that addresses this in our briefing. I think it's Health Alliance. And it points to the fact that what we're talking about is a corporate representative deposition. So it doesn't have to be of the lawyer. It is someone speaking on behalf of the party in the lawsuit, answering questions on things like, yes, I'm claiming these damages. No, I'm not claiming these damages. Helping to narrow the issues for trial. And those are kind of basic forms of discovery that we should be allowed to secure, that we just can't get complete answers to those things through written discovery. And we can't get the answers to some of those basic questions through expert discovery either, because experts have their narrow area. And we can't, for example, the state is alleging an injunction in both cases, which I find remarkable that they're saying consumer harm is not relevant when they're seeking an injunction to prevent against consumer harm. But we're allowed to ask factual questions related to things like the request for an injunction, where expert testimony isn't going to cover those issues. So there are just significant gaps here that are left in our ability to get discovery if we don't get a corporate representative deposition. What the state is ultimately saying is, because we are the state of Texas, we get a pass on the rules of civil procedure. Boil their arguments down to their essence, and
No,
that's what they're saying.
Just one rule of procedure.
Really, all of them, because when you think about this argument that, well, no, really, for example, the hearing in Midland last week. Well, we're sort of the lawyer, we're sort of the state, so we have all of these protections. We don't really have to answer any of your questions. We get to sue you. We get to have 150 hours of depositions from you, but you don't get a single hour of deposition from us. There's a fundamental fairness problem with this position, and I would suggest that there are implications of this position, not just for this case, but for future litigation involving the state. Thank you for your time today and the opportunity to present argument.
Let me ask you one last question that I
Yes.
meant to ask Mr. Cole, but he ran out of time. The way that a civil enforcement action gets filed, as I understand it, is that a particular agency finds out that there's been some violation of a statute. And they refer the matter to the AG's office to file suit. As I have seen it, some of these suits are filed in the name of the agency, and some of the suits are filed in the name of the state of Texas. Mm-hmm. How does that get decided, and who decides it? Do you know?
I will be honest and say I don't know the answer for every context, Your Honor. I know in this context, the statutes that are at issue specifically say that the AG brings suit to enforce the statute in the name of the state of Texas.
Yeah, the agency, in a lot of these statutes, the agency can bring the suit, or they can refer it to the AG's office, or maybe they have to refer it to I don't know who makes the decision about who's the plaintiff.
I believe that's usually set by statute, Judge, and I know that there are many cases where the AG would be bringing suit to enforce a statute on behalf of the state of Texas, which is why I say the implications of this issue are significant. Thank you.
Thank you. The case is be submitted. We'll stand adjourned for about 5 minutes while we change the panel.
The